Good morning, everyone. I will be timing myself, so Chair, don't worry. I think just before I get to the business, I'd just like to share with you that besides the nerves, I'm extremely humbled. I'm feeling a bit emotional about having this opportunity to share my research with you and to also have studied or done research in the law of the sea as a Black woman, specifically one born in a landlocked state, low income state at that. So it is such an amazing opportunity. Thank you so much for this invitation. So don't worry. Thank you. I will save the waterworks, pun intended, for later on when I get to my room and I'm sitting alone and like, oh my gosh. But yeah, let's get to the business, okay? I'm not going to bother reading the title of my talk. It's there in front of you. It's based on a paper that I'm currently co-authoring with Professor Patrick Franken, who is the SACHI chair on the law of the sea and development in Africa. So watch the space for when this paper is published. Okay, so let's set the scene. My discussion today will predominantly be based on the United Nations Convention on the Law of the Sea, the framework there. The reason for that is because it's the main instrument that regulates mining activities in the area. So that's the crux of the discussion. Now, to set the scene, what is this area that I'm talking about and making a big fuss about? Where is it? Okay, the area is the seabed, ocean floor, and subsoil beyond the limits of national jurisdiction. No state has sovereign rights or sovereignty over the area or its resources. They're the common heritage of mankind. The LOSC, the United Nations Convention on the Law of the Sea, has established the International Seabed Authority as the custodian of the area and its mineral resources on behalf of humanity, common heritage of mankind. So on behalf of humanity, the International Seabed Authority is responsible for developing deep seabed mining regime. It's responsible for then granting exploration and exploitation licenses for mineral resources in the area. At the current moment, exploitation has not yet commenced. However, there have been 31 exploration licenses that have been granted. So that's more or less where we are, okay? So why mine in the area? Why the big hoo-ha? Okay, there has been in recent years growing demand for rare earth elements and mineral resources, specifically by tech companies and the renewable energy sector. For instance, for the manufacture of wind turbines and solar panels, the list goes on. Another thing is there's this growing or sharp decline of mineral resources in the terrestrial environment. We know then that the Earth is actually more ocean than it is land, which is funny why we refer to it as Earth and not ocean. But the area, looking at the area, the size of the area, it's 54% of the world's ocean space. So the area and the high seas above it, that's the majority of the ocean space. So that means there's a higher potential of then being able to find these mineral resources that we need or want, whichever side of the spectrum you are on, in the area. The Western and Central Pacific, for instance, has a greater potential of ferromanganese crust mining. The Central Pacific contains approximately 4 times more cobalt reserves than those that we find on land. There's also monetary issue, okay, or monetary incentive, which is that the deep seabed mining industry is projected to then be a multi-trillion-dollar business. So since the International Seabed Authority is the custodian of the area and its resources for the benefit of humanity, does the International Seabed Authority have environmental protection obligations? There's a number of environmental protection obligations in LOSC, but here I'm focusing specifically on the International Seabed Authority. If we read Article 145, for instance, we see that the International Seabed Authority must adopt appropriate rules, procedures, and regulations to prevent, reduce, and control pollution to the marine environment. It must do this by paying particular attention to the protection of the environment from harmful effects from, for instance, drilling, excavation, and disposal of waste. And we know that these activities are specifically connected with mining. It also then has the obligation to protect and conserve the natural resources of the area and prevent damage to fauna and flora in the marine environment. In terms of Article 162, the Council, which is the executive wing of the International Seabed Authority, to protect the marine environment, can issue, for instance, emergency orders. It can suspend mining. It can adjust mining operations and so forth. It can also disapprove certain areas for exploitation if there is sufficient evidence that environmental harm will occur. There's a risk of environmental harm. So that's essentially, there's a lot more I could talk about, but I've just chosen to focus there for the interest of time. So those are the environmental protection obligations of the International Seabed Authority. What then are possible grounds that we can rely on for a moratorium? Well, I think about 4 of them. The first ground then, and arguably the most important, is the serious and potentially irreversible harm to the marine environment that will be caused by these mining activities, okay? Because of the distance of where the area is from land and the harsh and extreme weather conditions out there in the deep sea, we have limited biological and geological baseline data on the areas, as well as the biodiversity in the area, right? And the ecosystems and the water column, but there is significant scientific data to prove that certain environmental harms will result, or there's a high potential that they will result from these mining activities. What are some of them? I'm not going to go through all of them in the interest of time, but for instance, the discharge of waste sediments and wastewater back into the ocean when there's minimal processing on board vessels. There's also going to be a high mortality rate of fish and small plankton near the mining area, as well as the altering and destruction of certain marine habitats, which might take years to return back to their pre-mining position, if they ever do. We also know that there's a great risk of transboundary pollution. Here, we're speaking about, for instance, noise pollution. And we know the science, for instance, from the seismic survey cases, that there's far-reaching impacts of noise pollution on marine mammals. So that's another thing that we have to consider here, as well as the increased risks of ore or oil spills from malfunctioning mining equipment out at sea. So what then happens? Another ground that we could also look towards exploring is, what about the precautionary approach? So given the limited scientific data that we currently have and the potential seriousness of the environmental harms that could be caused, is a moratorium not then the best available measure to protect the environment and prevent harm until we know sufficiently enough or better understand the area and its biodiversity? My third ground, what about the economic viability of mining activities in the area? So yes, there's this projection that it will be a multi-trillion-dollar business, but to fully understand the economic viability of this industry, it depends on the environmental footprint. So we need to determine, in order to determine the economic costs and benefits of this industry, we need to assess what the potential gross profits would be, And then also, amongst others, try to determine or estimate what the environmental compensation costs would be. And then only after that can we get a sense of what our net profits would be. And given already the extent of the environmental harm and the claims that are then going to come left, right, and center, is it then economically viable? Is it worth us doing all of this to get very little out of it anyway? So that's a ground we could look at. And then the fourth one is the inspection and environmental monitoring capacity of the International Seabed Authority. So until recently, the International Seabed Authority has primarily relied on compliance and monitoring mechanisms that are linked to the annual reports that contractors submit, as well as the periodical review of plans of work or mining contracts or applications. And those are done once every 5 years. So a mining contract or an exploration contract is for a 15-year period. So for the duration of that contract, it means that this is only going to be done 3 times. Another thing is that just last year, 2023, the International Seabed Authority completed its first inspections and investigations of contractors' compliance with LOSC and the International Seabed Authority's mining codes, as well as their terms and conditions of their contract. However, there's only 3 such inspection reports and investigation reports that have been done. But as I said, 31 exploration contracts have been granted. Where are the rest? So this then means that, because essentially exploration, the first exploration contract was granted in 2021. So it means certain exploration contracts have expired and been renewed without then this investigation and inspection taking place. So given that, if that is our current dilemma at exploration level, how then will the International Seabed Authority be able to implement effective ecosystem-based management measures that are necessary to strike the balance between exploitation and the protection of the marine environment when exploitation now commences? Because we're already failing to do this at exploration level. So those are my, some grounds, some thoughts on what we can rely on. But, and this is a big but, there is always another side of the coin. What then are the arguments against a moratorium? And yeah, I'm very passionate about this first one. That's the basis of why I entered this research in the first place. So further disadvantaging the African continent and its people, who we know through history have been previously disadvantaged and continue to be disadvantaged. So at the moment, I did say that there's these 31 exploration contracts that have been granted, but none of them have been granted to an African state. Africa is the only region that is not participating in activities in the area. So there are other developing states that have contracts, but for our region, nothing. And if you look at the development on international law, specifically the law of the sea, you will know that the African continent was excluded from a lot of this development. And the reason why was because we were still under colonial rule. Well, most of African states still were. They were not independent states. So they couldn't participate, they couldn't have a say. LOSC, for instance, was adopted in 1982. What was the position in South Africa at that time? So it means we essentially didn't have strong seat at the table. So what does this moratorium mean for Africa and African states? Why are they not participating? There's a number of reasons, but amongst the key to those reasons is financial and technological constraints. Deep seabed mining is a capital-intensive industry. So the longer we prolong exploitation, the longer it will take for the operationalization of the enterprise. The enterprise is the mining wing of the International Seabed Authority. A number of African states are currently relying on the operationalization of the enterprise in order for them to be assisted in obtaining their own contracts. You might ask, how? How does this assist them? Well, LOSC specifically provides that the enterprise can engage or enter into joint ventures with developing states. And then the enterprise, the International Seabed Authority, obviously is in a better financial and technological position to be able to fund these type of projects. So if we were to engage in that joint venture, we would then drop the load off our shoulders when it comes to this financial and technological aspect, this barrier to our entry. Still linked to this is no exploitation also means no equitable benefit sharing. And law specifically provides that developing states must be prioritized when it comes to equitable benefit sharing. But equitable benefit sharing, when it comes to mineral resources in the area and the profits derived therefrom, will only commence when exploitation, commercial exploitation, actually commences itself. So some African states are actually waiting for those profits, their share of the profits that they will derive from this, to be able to fund some of their own mining contracts. So with that, where are we? If we specifically look at Article 148 of LOSC, law specifically says that there's a need to ensure the effective participation of developing states, including landlocked states, in mining activities in the area. So given the position that we have now, can we achieve transformation if African states continue to be excluded? Can we realize the principle of the common heritage of mankind if African states still cannot effectively participate? And then the second one is, what about the 2-year finalization rule? So if we read section 1, paragraph 15 of the annex of the 1994 implementation agreement of Part 11 of LOSC, it specifically provides that where a state or its sponsored contractor intends to apply for an exploration license, and at that time, the International Seabed Authority has not finalized its exploration regime, that state can request the International Seabed Authority to finalize that exploration regime within a 2-year period. What then happens if this 2-year period lapses before the International Seabed Authority has finalized these exploration regulations? Well, if you read section 1, paragraph 15C of the implementation agreement, you will see that in line with the principle of non-discrimination of contractors, the International Seabed Authority must then provisionally approve that mining application based on the provisions of LOSC and its provisional exploration regulation. So essentially, does that mean we can actually proceed to exploration at this stage? What is interesting, this 2-year period has actually been invoked. On the 30th of June, 2021 is when it started, and then it expired on the 30th of June, 2023. And the regime, exploration regime, still has not been finalized. Who invoked this 2-year rule? It was actually a developing state. Nauru, a small Pacific island state, the first developing state to obtain an exploration contract from the International Seabed Authority. It's the one that said, we're running out of time, let's move on. So that is interesting. Now I conclude. What is the way forward? Pose some questions to you as the room. Can we strike a balance between these conflicting rights and interests in the area? And how then can we bring all the key role players to the table to work towards achieving development on the one hand, but most importantly, sustainability. So sustainable development. How do we do that? So with that, thank you.